Good morning everyone, Philip Nam here from White Collar Legal. Just doing a brief video on evictions under grounds 10 and 11. We're talking about residential evictions in England only. Just a little bit about me, of course, the usual spiel. And a little bit about who uses White Collar Legal. Yes, solicitors and barristers do use us. So, seeing this question on Facebook today, that the poster has got a court hearing next week to evict tenants for rent arrears, but the tenant has just paid rent, which means they're under the 2-month threshold for ground 8. They only use section 8, and they were asking for people's experiences and management to evict the tenants under grounds 10 and 11 and any other resolution. So a tenancy, residential tenancy, can only come to an end either by the tenant agreeing it comes to an end or the court making an order. So one resolution is you can't actually negotiate with your tenants, maybe pay them some money to leave. We'll try and get everything agreed in writing. Grounds 10 and 11 are discretionary grounds. That means the court will only order possession if they consider it just and reasonable to do so. And the court will take into account all the circumstances, so it's very important that at the start of your claim, when you're filling in the claim form and particulars of claim, you are setting out the circumstances that will assist the court in coming to a decision. There is a section on the particulars of claim for that. Many people do not fill it in, but the court need to take that into account. So the other typical direction or requirements for possession hearings is witness evidence. Witness statements need to be sent 2 days before the hearing. Best get it done ASAP. Witness statements is to prove the case, and especially in this type of case, grounds 10 and 11. Circumstances that might be relevant, that the tenant might have had a very long history of paying late. They might be up and down with their rent arrears. They might always be in arrears, even if it's not below 2 months. So the court might take that into consideration. It's really unfair on a landlord who is expecting to receive rent to not receive it, or to receive it late or be shortchanged. Other circumstances, the landlord may have a mortgage to pay, and the rent might be, the exact sum of the mortgage payments. It might be less, it might be more, but there could be late payment charges. There might be financial difficulty for the landlord. They might be an accidental landlord. They might not be running it for business purposes. They could have just become a landlord by accident. A family member passed away who was the landlord. So all these circumstances are useful to set out in the particulars of claim and perhaps in witness evidence. The other option for the court is that the court may order a possession order on grounds 10 and 11, but suspend it on conditions that the tenant pays the arrears off or makes certain payments. So if you're doing these hearings yourself as a landlord, or instructing a solicitor or an advocate to attend court, make sure you get your advocate or solicitor or barrister to make the case for a suspended possession order, because at least you have it in the bank in case the tenant breaches again. It's always important to get advice from a professional. Some of the things we do include civil law and includes residential landlord and tenant matters, and I've done over 600 court hearings overall, most of those being landlord and tenant matters. But we also provide advice, draft legal documents, and help resolve disputes. And hopefully we're up to 67% cheaper than solicitors. So by all means, get in touch. There's our contact details. Get on Trustpilot, get on Facebook, make an appointment. Thanks.